Before we begin, a quick and important disclaimer. The following content is provided strictly for educational and entertainment purposes. It does not constitute legal, financial, or professional advice, and no attorney-client relationship is formed by viewing this material. Laws regarding domestic relations vary significantly by jurisdiction and are subject to change. Viewers are strongly encouraged to conduct their own due diligence and consult with a licensed professional in their specific state or region before making any decisions related to legal proceedings. Imagine for a moment that you are a resident of New York in the year 1950. You are trapped in a marriage that has become a hollow shell. Yet under the law you are bound for life. There is only one escape route: proving your spouse committed adultery. But what if they didn't? In this era, the burgeoning industry of the U.S. divorce attorney gave rise to one of the most bizarre and ethically gray chapters in American legal history: the staged raid. Attorneys would literally hire professional correspondents, usually young women in silk robes, to pose in hotel rooms with their clients. A private investigator would then burst in, take a flashbulb photograph, and provide the evidence required by the court. This was the theater of the law, a period where the divorce attorney wasn't just a legal representative, but a director of a scripted drama. Today, the U.S. divorce industry is a $50 billion a year powerhouse, but its roots are buried in a world of social shame, private investigators, and legislative battles that shape the very fabric of the American family. By the end of this deep dive masterclass, you will understand the machinery behind the modern family court system. We are going to peel back the curtain on how the divorce attorney evolved from a social pariah into a high-stakes strategist. For anyone navigating the complexities of the modern legal system, understanding these historical trends and case studies is the only way to grasp why the process is as adversarial, expensive, and intricate as it is today. We are solving the mystery of the billable hour by looking at the centuries of precedent that built it. To understand where we are, we must look at the foundation of the American legal system: English common law. In the early colonial period, the concept of a divorce attorney, as we know it today, simply did not exist. This was due to a legal doctrine known as coverture. Under coverture, a woman's legal identity was merged into her husband's upon marriage. She could not own property, enter into contracts, or sue in court in her own name. Because a woman had no independent legal standing, the idea of hiring an attorney to dissolve a marriage was practically an oxymoron. During the 17th and 18th centuries, divorce was not a judicial matter handled by a local court. It was a legislative one. If you wanted a divorce in Virginia or Pennsylvania, you didn't file a motion. You petitioned the colonial assembly or the state legislature. This meant that the attorneys involved were often lobbyists or politicians. A bill had to be passed specifically for your individual marriage to be dissolved. Historical trends show that these legislative divorces were reserved almost exclusively for the ultra-wealthy and the politically connected. For the average person, divorce usually meant desertion, simply walking away and moving to a different frontier town to start over. This created a legal vacuum that the professional attorney would eventually fill. As the United States moved into the 19th century, the demand for a more accessible legal exit from marriage grew. This gave rise to the era of the divorce mill. This is where the specialized divorce attorney first began to flex their muscles. States like Indiana and later South Dakota and Nevada realized that by loosening their residency requirements and expanding the grounds for divorce, they could attract a massive amount of legal business. Let's look at the case study of Indiana in the 1850s. At a time when New York only allowed divorce for adultery, Indiana allowed it for any other cause for which the court shall deem it proper. This vague language was a goldmine for attorneys. They began advertising their services in Eastern newspapers, essentially promising a way out. This was the birth of the migratory divorce. An attorney in Indianapolis would set up a practice specifically to help wealthy New Yorkers establish a sham residency for 6 months, file for divorce, and then leave. This turned the law into a product. The attorney was no longer just an officer of the court, they were a facilitator of a service. The 19th century divorce attorney also had to navigate the fault-based system. This is a crucial concept to understand because it still haunts our legal language today. For over 150 years, you couldn't just want a divorce. You had to prove that your spouse had committed a legal wrong. The primary categories were adultery, the gold standard of fault; cruelty, which originally had to be physical violence, but attorneys slowly expanded it to mental cruelty; desertion, leaving the home for a specific period, usually 1 to 2 years; The role of the attorney in this system was to gather evidence of sin. This led to the symbiotic relationship between law firms and private investigators. Attorneys would spend thousands of billable hours tracking movements, interviewing disgruntled domestic servants, and reviewing financial ledgers. Every divorce became a whodunit mystery, and the attorney was the lead detective. This adversarial nature is the primary reason why divorce became so expensive. When you have to prove a crime to get a decree, the legal fees skyrocket. By the early 20th century, the legal profession began to formalize. The American Bar Association started to look at domestic relations as a distinct field. However, it was still considered dirty work by the white shoe firms of Wall Street. A divorce attorney was often seen as someone who dealt in the sewer of human emotions. This social stigma actually allowed for the rise of the gladiator archetype. These were attorneys who didn't care about social standing. They cared about winning. They leaned into the conflict. A pivotal shift occurred with the no-fault revolution, starting with California's Family Law Act of 1969, signed by then-Governor Ronald Reagan. This fundamentally changed the attorney's job description. Suddenly, you didn't need to prove adultery. You only needed to cite irreconcilable differences. Many thought this would put divorce attorneys out of business. If the conflict of proving fault was gone, why would you need an expensive lawyer? The reality was the exact opposite. When the focus shifted away from why the marriage ended, it shifted toward how the assets would be split. This is the era of equitable distribution and community property. The divorce attorney transformed from a private investigator into a financial forensic expert. They had to learn how to value businesses, split pension plans, and navigate the tax implications of alimony. The complexity of the law didn't decrease. It simply moved from the bedroom to the boardroom. Consider the data. In 1960, the U.S. divorce rate was roughly 2.2 per 1,000 people. By 1980, following the widespread adoption of no-fault laws, it peaked at 5.3 per 1,000. This explosion in volume created a massive market. Law schools began offering specialized tracks in family law. The general practitioner, who did a little bit of real estate and a little bit of divorce, was replaced by the certified family law specialist. Step by step, the process became more bureaucratic. Attorneys had to master discovery, the formal process of exchanging information, which can involve thousands of pages of bank statements, temporary orders, legal skirmishes over who stays in the house and who pays the bills while the case is pending, mediation, a mandatory step in many states where attorneys try to settle before a judge intervenes. The history of the U.S. divorce attorney is the history of the American middle class. As we acquired more assets, homes, 401ks, stock options, the attorney's role became more essential to protecting one's future financial potential outcomes. We are no longer looking at moral crimes. We are looking at the dissolution of a partnership. This historical perspective reveals that the current system isn't broken by accident. It was built over 300 years to manage the collision of human emotion and property rights. Understanding this evolution is the first step in navigating the modern legal landscape with clarity, rather than frustration. In the next part of this series, we will examine the specific case studies of the 1920s socialite divorces that set the stage for the celebrity legal battles of the 21st century. To understand the explosion of the divorce attorney as a cultural and legal power player, we have to travel back to the Roaring Twenties. Imagine if you are a high society figure in 1926 New York. The stock market is soaring, jazz is playing in every club, and the social constraints of the Victorian era are melting away. However, the legal system is still a frozen relic of the past. In New York, the only way to secure a divorce is still through proving adultery, a process that is messy, public, and often involves hiring individuals to stage compromising photos. But for the wealthy elite, a new breed of attorney was emerging. The strategist who realized that if the law in your home state was a wall, you could simply fly, sail, or take a train over it. This era birthed the Reno Cure, a phenomenon that fundamentally changed how U.S. attorneys practice family law. In the 1920s, Nevada realized it could turn its lax divorce laws into a massive revenue stream. While most states required a year or more of residency to file for divorce, Nevada slashed that requirement to just 6 months, and eventually to a mere 6 weeks. For a divorce attorney in 1926, this was a revolutionary tool. They began acting as travel agents and relocation specialists. They would coordinate their clients' stays at divorce ranches, where wealthy socialites would spend 6 weeks riding horses and playing bridge while waiting for their residency to vest. Consider the logistical precision required here. The attorney had to ensure the client followed every residency rule to the letter, or the final decree would be worthless back home. They had to document the client's presence in Nevada, often having them register to vote or open a local bank account. This was the first time we saw the divorce attorney become a master of jurisdictional maneuvering. Historical trends show that by the late 1920s, Reno was granting over 2,500 divorces a year, with nearly all of them being facilitated by out-of-state attorneys funneling clients into the Nevada system. But if Reno was for the upper middle class, the ultra-wealthy looked even further: Paris. During the 1920s, the Paris divorce became the ultimate status symbol for the American elite. French law at the time was significantly more lenient regarding mutual consent. A U.S. attorney would partner with a French avocat to navigate a system that allowed for a quick, quiet dissolution of marriage far from the prying eyes of the New York tabloids. This created a massive legal loophole. Case studies of the era show that U.S. courts were often forced to recognize these foreign decrees under the principle of comity, or mutual respect between nations. The divorce attorney's role was to build a legal bridge between Manhattan and the Seine, ensuring that when their client returned to the States, their new marital status was bulletproof. As we look at the year 2026, we see the echoes of these 1920s strategies in how modern attorneys handle private judging. Just as 1920s socialites fled to Reno for privacy and speed, today's high-net-worth individuals often hire retired judges to hear their cases in private law offices, away from the public record. The DNA of the modern celebrity divorce was written in the 1920s by lawyers who realized that for the right price, the law could be made convenient. Let's dive into a specific imagine-if scenario to see how this worked on the ground. Imagine a woman named Evelyn in 1927. She is married to a shipping magnate, but they have lived separate lives for years. Under New York law, she has no leverage. If she sues for divorce on the grounds of cruelty, she has to provide witnesses of physical violence, which doesn't exist. If she tries to prove adultery, she risks a public scandal that would ruin her social standing. Her attorney, a savvy fixer type, suggests the Reno route. Step 1. The attorney coordinates a secret departure. Step 2. He secures her a room at a specialized ranch in Washoe County. Step 3. He handles the paperwork to establish her intent to remain in Nevada indefinitely, even though everyone knows she will leave the moment the judge bangs the gavel. Step 4. He negotiates a separation agreement in New York that is then incorporated into the Nevada decree. This was the birth of the modern settlement. By moving the battlefield to a more favorable jurisdiction, the attorney forced the husband's legal team to the negotiating table. They weren't fighting about sin anymore. They were fighting about the price of an exit. This period also saw the rise of the alimony battle as a staple of American news. As divorce became more common among the wealthy, the amounts of money involved became astronomical. Attorneys began to specialize in alimony defense and alimony pursuit. We see the beginning of the standard of living argument. In the 1920s, attorneys successfully argued that a divorced wife should be maintained in the same level of luxury she enjoyed during the marriage. This wasn't just about survival. It was about the continuation of a lifestyle. This historical trend set the precedent for the multi-million-dollar alimony awards we see in modern 2026 case studies. However, this era wasn't without its casualties. The divorce mills of the 1920s created a massive ethical debate within the American Bar Association. Critics argued that these attorneys were making a mockery of the law by facilitating sham residencies. This led to a tightening of professional ethics codes, but the cat was out of the bag. The American public had seen that divorce could be a civil, albeit expensive, transaction rather than a moral catastrophe. The divorce attorney had successfully rebranded from a shyster into a specialist. The complexity of these 1920s cases also forced the development of forensic accounting, though they didn't call it that yet. Attorneys had to become experts in tracing assets. If a husband tried to hide his wealth in offshore accounts or complex corporate structures to avoid a large settlement, the attorney had to find it. This required a level of financial literacy that was previously unnecessary in family law. We start to see the first instances of document production requests, where lawyers would spend weeks combing through ledger books and stock certificates. By the end of the 1920s, the blueprint for the modern U.S. divorce attorney was complete. They were now part investigator, part accountant, part PR manager, and part jurisdictional strategist. They had learned how to use the media to pressure opponents, how to use forum shopping to find the most favorable laws, and how to turn a domestic dispute into a sophisticated piece of litigation. This golden age of the socialite divorce proved that the legal system would always adapt to meet the needs of those who could afford to navigate its complexities. But as the 1920s faded into the Great Depression, the Reno Cure and the Paris divorce became luxuries few could afford. The legal landscape was about to shift again, moving away from the glamour of the divorce ranch and into the gritty, high-stakes world of the 1940s and 50s, where the stakes weren't just about lifestyle, but about the custody of children and the very definition of the American family. What happens when the theater of the law turns into a battlefield for the soul of the home? How did the post-war era create the private eye lawyer, who specialized in wiretaps and tailing cars? We are about to enter the darkest, most controversial chapter of this history, the era of the picket fence war. In the next part, we will explore the rise of the professional accuser in the 1950s, and how the invention of the tape recorder changed the divorce attorney's arsenal forever. You will see how the fight for the kids became the ultimate legal weapon. The shift from the glamorous, high society escapes of the 1920s to the domestic battlefields of the 1940s and 50s was a tectonic movement in the history of the U.S. divorce attorney. As the United States emerged from World War II, the nation was gripped by a cult of domesticity. The suburban dream, the house, the car, and the 2 children, wasn't just a lifestyle choice. It was a patriotic duty. Consequently, ending a marriage became a catastrophic social failure. This created a new, darker incentive structure for the legal profession. In the 1950s, the divorce attorney was no longer just a facilitator of paperwork. They became a professional accuser. Because fault was still the only legal key to unlock the door of a marriage, the attorney's primary job was to destroy the character of the opposing party. Imagine if you are a husband named Robert in 1954, living in a typical American suburb. You want to leave your marriage, but your wife does not. Under the laws of the time, you cannot simply leave. To win your freedom and protect your assets, your attorney informs you that you must prove your wife is legally at fault. This is where the strategy of the professional accuser begins. The attorney doesn't just look for evidence. They help manufacture the environment where evidence can be found. They might suggest you leave the house for a weekend to see if she invites anyone over, while a private investigator hired by the firm sits in a car down the street with a long-lens camera. This was the era where the divorce attorney and the private eye became inseparable. Historical trends show that by 1955, over 80% of matrimonial cases in major cities involved some form of professional surveillance. The 1950s also introduced a transformative and terrifying new weapon into the attorney's arsenal: the portable wiretap and the early tape recorder. Before the landmark privacy rulings of the late 1960s, the legal status of recording a spouse without their knowledge was a murky, often permissible gray area. Attorneys would instruct their clients on how to install a bug in their own home phone. Imagine the high-stakes tension as an attorney sits in a wood-paneled office in 1956, playing back a grainy magnetic tape of a private conversation to use as leverage in a settlement meeting. The goal was rarely to actually go to trial with this evidence. The goal was the nuclear option. The attorney would show the tape to the opposing counsel, essentially saying, "If you don't agree to our terms on the house and the savings, we will play this in open court and ruin your client's reputation in the community." This was legal extortion refined into a professional service. This period also saw the rise of the most high-stakes conflict in family law: the battle for child custody. For much of early American history, children were legally seen as the property of the father. However, by the mid-20th century, the legal pendulum had swung to the tender years doctrine. This was a judicial presumption that during their tender years, generally under the age of 7, children belonged with their mother. For a father's attorney in the 1950s, this created a massive legal hurdle. To win custody for a father, the attorney had to prove that the mother was unfit. This led to some of the most brutal character assassinations in legal history. Case studies from this era show attorneys digging into every corner of a mother's life. Did she have a glass of sherry in the afternoon? That was portrayed as alcoholism. Did she attend a political meeting that was deemed too radical? That was portrayed as social instability. The attorney's role was to take ordinary human flaws and magnify them through the lens of 1950s morality, until they became legal grounds for losing one's children. This wasn't just about the law, it was about the weaponization of social norms. As we look at these cases from the perspective of 2026, the tactics seem barbaric, but they were the standard operating procedure for the top-tier matrimonial firms of the time. Step by step, the 1950s divorce attorney was also developing the first iterations of what we now call forensic psychology. They began to realize that a judge's opinion could be swayed by expert testimony. Lawyers started bringing in early child psychologists and social workers to testify about the moral atmosphere of a home. This added a new layer of expense and complexity. Now the attorney had to manage a team of experts. They had to prep these witnesses to ensure their scientific findings aligned with the legal narrative being built. This was the beginning of the battle of the experts that dominates modern family court in 2026. The financial stakes were also evolving. In the post-war boom, the American middle class suddenly had significant equity in their homes and growing pension funds. The divorce attorney had to become a student of the emerging tax code. They had to figure out how to structure alimony payments so they were tax-deductible for the payer and taxable for the receiver, a strategy that remained a staple of the industry for decades. The separation agreement became a massive, complex document that attempted to predict the future financial needs of a family that was being ripped apart. Furthermore, the 1950s saw the birth of the conflict of interest as a major legal hurdle. As firms grew, the elite divorce attorneys often found themselves in a small circle. If a wealthy businessman hired the top attorney in town, his wife was often left searching for someone who wasn't already conflicted out. This led to a strategic move still used today: conflict shopping. A savvy client would have initial consultations with the 5 best attorneys in the city, even if they only intended to hire one. Because those 5 attorneys had now heard the details of the case, they were legally barred from representing the spouse. It was a move designed to leave the opponent defenseless, and it was the divorce attorney who pioneered this tactical use of ethics rules. By the end of the 1950s, the U.S. divorce attorney had become a figure of both fear and necessity. They were the ones who knew the secrets behind the picket fences. They were the ones who knew which judges were susceptible to which arguments. They had moved from being simple law talkers to being the architects of a client's entire future existence. The cost of these services began to climb as the billable hour became more formalized. In 1950, a divorce might cost a few $100s. By 1959, a contested case involving custody and property could easily reach into the thousands, tens of thousands in today's currency. But the world was about to change. The rigid morality of the 1950s was cracking, and the very foundation of fault-based divorce was about to be challenged by a new generation of legal scholars and activists. The professional accuser was about to face their greatest challenge: a system where the accusal was no longer necessary. What happens to an industry built on proving sin when the law decides that sin no longer matters? How did the legal profession pivot when the no-fault era began? And how did they find new ways to keep the billable hours climbing, even when the drama of the private investigator was taken away? We are moving into the 1960s and 70s, the era of the great radicalization of family law. In the next part, we will look at the exact moment the fault system collapsed, and how a future president of the United States inadvertently created the modern, high-speed divorce machine. You will see how the attorney's role shifted from detective to accountant almost overnight, and the new ways they found to keep the stakes higher than ever. The transition into the late 1960s and early 1970s marked the most radical shift in the history of the U.S. divorce attorney. For over a century, the legal profession had operated under the assumption that marriage was a permanent contract that could only be broken by a moral failing. But by 1969, the legal system was reaching a breaking point. Judges and attorneys alike were exhausted by the charade of the fault-based system. The staged hotel room raids, the coached perjury, and the manufactured evidence of the 1950s had created a crisis of integrity in the American courtroom. Attorneys were effectively forced to be directors of fiction, just to get their clients a legal exit. This internal pressure cooker led to a legislative explosion in California that would change the world. Imagine if you are a law clerk in the office of Governor Ronald Reagan in 1969. You are handed the Family Law Act. At the time, Reagan, who was the only U.S. president to have been divorced, signed this bill into law, making California the first state to adopt a true no-fault divorce system. This was the birth of the irreconcilable differences standard. For the divorce attorney, this was a terrifying moment of professional existentialism. If you no longer had to prove a crime, if you no longer needed a private investigator to catch someone in the act, what exactly were you charging for? Many practitioners feared that the divorce attorney would become obsolete, replaced by simple administrative forms and a handshake. However, historical trends show that the exact opposite occurred. As the why of divorce became irrelevant to the state, the what and how became infinitely more complex. The divorce attorney didn't disappear. They evolved into a high-stakes financial architect. This shift was fueled by the massive economic changes of the 1970s. This was the era of the dual-income household, the rise of the professional woman, and the invention of modern retirement vehicles. In 1974, the United States passed the Employee Retirement Income Security Act, commonly known as ERISA. Suddenly, a husband's pension or a wife's 401k wasn't just a future benefit. It was a marital asset that could be divided. Step by step, the attorney's office transformed from a detective's lair into a forensic laboratory. Instead of developing film from a private eye, the modern attorney in 1975 was now hiring actuaries to determine the present value of a pension that wouldn't pay out for 20 years. They had to learn the intricacies of the Qualified Domestic Relations Order, or QDRO. This is a highly technical legal instrument that allows a retirement plan to pay a portion of its benefits to an ex-spouse without triggering immediate tax penalties. If an attorney messed up a QDRO, the potential outcomes for the client were catastrophic, leading to massive tax liabilities. This complexity meant that the billable hour didn't just survive, it thrived. The time previously spent following a spouse to a motel was now spent in discovery, the formal and exhaustive process of exchanging financial records. Let's look at a case study from the mid-1970s that illustrates this shift. Imagine a couple named James and Sarah. James is a middle manager with a solid corporate pension. Sarah has spent a decade raising their children, but has recently returned to the workforce. Under the old system, if James wanted a divorce, he would have to prove Sarah did something wrong. Under the new no-fault law, James can simply file. But Sarah's attorney now has a new set of weapons. Instead of looking for a lover, Sarah's attorney looks for the money. They file a request for production of documents, demanding every bank statement, tax return, and credit card bill from the last 10 years. This was the beginning of the paper war. The attorney's job was to find the hidden value. Was James using marital funds to invest in a side business? Was he deferring bonuses until after the divorce was final? The attorney was no longer a moral arbiter. They were a financial hunter. This era also birthed a controversial legal concept that would push the limits of what a divorce attorney could claim as marital property: the valuation of a professional degree. In the landmark case study of O'Brien v. O'Brien in New York, the court was asked to decide if a medical license obtained during the marriage was an asset that could be valued and divided. Sarah's attorney in 2026 would look back at this as a turning point. The court ruled that because the wife had worked to support the husband through medical school, she was entitled to a portion of his future enhanced earning capacity. This required attorneys to hire economic experts to calculate how much more a doctor would earn over a lifetime compared to someone with just a college degree. The divorce attorney was now litigating the value of a client's future. By the late 1970s, the divorce rate in the United States had doubled. The social stigma was evaporating, replaced by a legal industry that was processing hundreds of thousands of cases a year. This volume led to the professionalization of the matrimonial bar. Organizations like the American Academy of Matrimonial Lawyers began to set higher standards for ethics and expertise. The divorce attorney was no longer a generalist. They were a specialist who understood tax law, contract law, and psychology. Imagine the atmosphere in a high-end divorce firm in 1979. The offices are no longer in the back of a building. They are in the prestigious high-rises. The attorneys are using early computers to track assets. The fast-paced nature of the job was becoming legendary. You weren't just a lawyer, you were a crisis manager. You were dealing with people at the absolute worst moments of their lives, but you were doing it with the cold precision of an accountant. This contrast between human emotional chaos and rigid financial calculations became the hallmark of the industry. We also see the rise of the prenuptial agreement during this period. As divorce became a known risk, a historical trend that showed no signs of slowing down, wealthy individuals and their attorneys began to look for ways to opt out of the state's default rules. The divorce attorney became a preventative specialist. They would draft complex contracts before the wedding to define what would happen if the marriage failed. This created a new paradox. The attorney was now involved in the marriage before it even began. As we move into the 1980s, the financial stakes would only get higher. The era of corporate raids, junk bonds, and massive personal wealth was about to collide with a legal system that was still trying to figure out how to be fair. But while the money was getting more complicated, a new and even more volatile storm was brewing in the courtrooms. The fight wasn't just about the 401k or the medical license anymore. It was moving back to the children, but with a new psychological twist that would change the lives of millions of American families. How did the best interests of the child standard turn from a gentle guideline into a multi-billion-dollar industry of custody evaluators and supervised visitations? And what happens when the divorce attorney realizes that the most valuable asset in the room isn't the house? It's the kids. In the next part, we will dive into the rise of the custody war. You will see how the legal system began to use psychological warfare to decide who gets the children, and how the invention of the joint custody movement changed the leverage in the lawyer's office forever. As the 1970s bled into the 1980s, the U.S. divorce attorney found themselves standing at the precipice of a new and deeply psychological frontier. The no-fault revolution had settled the question of whether a marriage could end, but it left a vacuum of conflict that was quickly filled by the most emotive and volatile asset of all: the children. For decades, the tender years doctrine had provided a predictable, if biased, framework. It presumed that mothers were the natural caregivers for young children, and unless a mother was proven to be fundamentally depraved, she would almost certainly receive custody. But as the 1980s began, this doctrine was struck down across the country as unconstitutional and gender-biased. In its place arose the best interests of the child standard. This sounds noble and simple on paper, but for the divorce attorney, it was the opening of Pandora's box. Unlike the old rules, the best interests of the child standard had no fixed definition. It was, and remains in 2026, a highly discretionary and subjective test. It gave judges the power to look at every single facet of a parent's life to determine where a child should live. To the divorce attorney, this ambiguity was a signal to mobilize. If a judge could decide based on anything, then everything was relevant. This birthed the era of the custody war, where the legal representative transformed from a financial liquidator into a psychological strategist. Imagine if you are a father named Michael in 1983. Under the old system, your attorney might have told you that seeking primary custody was a lost cause unless your wife was a criminal. But in the 1980s, your attorney tells you that the door is wide open. However, to walk through it, you need more than just a good job and a clean record. You need to prove that you are the psychologically superior parent. This led to the introduction of a new player in the courtroom: the forensic custody evaluator. The custody evaluator, usually a PhD-level psychologist, became the divorce attorney's most powerful and expensive ally. The process, which is still a staple of high-conflict cases today, involves a step-by-step deconstruction of the family unit. The attorney coordinates a series of interviews, home visits, and standardized psychological tests, like the Minnesota Multiphasic Personality Inventory. The attorney's role shifted to prepping their client for these evaluations. They weren't just practicing cross-examination. They were coaching parents on how to appear more nurturing, how to subtly pathologize the other parent's behavior, and how to navigate the complex social dynamics of a supervised observation. Historical trends show that the use of private custody evaluators increased by over 400% during the 1980s, creating a secondary industry that fed directly into the legal system's billable hours. This era also saw the rise of the guardian ad litem, or GAL. This is an attorney appointed specifically to represent the child's interests. Suddenly, a divorce case didn't just have two lawyers, it had three. The GAL became a powerful gatekeeper. A savvy divorce attorney realized that winning over the GAL was often more important than winning over the judge. This created a new layer of legal maneuvering where attorneys would lobby the GAL, providing them with curated evidence of the other parent's shortcomings. The cost of a divorce tripled during this period because the labor required to manage two opposing attorneys and a neutral evaluator became a full-time logistical operation. In 1980, California once again led the charge by becoming the first state to pass a joint custody statute. This was sold as a way to ensure both parents remained involved, but in the hands of a skilled divorce attorney, joint custody became the ultimate bargaining chip. We see a recurring case study in this era: the use of custody as leverage for financial gain. An attorney might advise a client to fight for 50-50 physical custody, not because they actually wanted the time, but because more time with the child often resulted in lower child support payments. This created a toxic environment where the child's schedule was traded like a commodity. The attorney became a negotiator of human time, calculating the exact number of overnights required to hit a specific financial potential outcome. Step by step, the 1980s attorney also had to master the art of the parenting plan. These documents grew from simple one-page agreements into 50-page manuals that dictated everything from which gas station A child would be dropped off at during a transition to how many telephone calls were allowed per week. Attorneys began using these plans as a form of slow-motion litigation. By baking in hundreds of tiny specific rules, they ensured that the parties would likely end up back in court for contempt of court or modification hearings for the next 18 years. The divorce was no longer a single event. It was the start of a multi-decade relationship with the legal system. Consider the case of a mother in 1987 who faced a husband using the new joint custody laws to avoid alimony. Her attorney's counter-strategy wasn't just to argue for the money, but to file for a psychological evaluation of the father, claiming that his desire for custody was a tactical sham rather than a genuine bond. This required hiring their own expert to rebut the court's expert. We see the birth of the battle of the experts, where two psychologists with the same degrees would stand on opposite sides of a courtroom and give diametrically opposed opinions on the same child's mental health. The attorney's job was to find the psychologist whose historical trends showed a bias toward their client's position. By the end of the 1980s, the divorce attorney had successfully professionalized the concept of high-conflict litigation. They had moved away from the sordid reputation of the 1950s and into the realm of family protection. But this protection came at a massive price, both financial and emotional. The legal system had become a machine that processed families through a sieve of psychological testing and financial disclosure. As we look at this through the lens of 2026, we see that the 1980s gave us the modern infrastructure of family court, the mediation requirements, the mandatory parenting classes, and the complex child support calculators. The attorney was now a technician who knew how to plug data into a formula to get a result. But as the 1990s approached, a new kind of wealth was being created in America. The rise of the Silicon Valley entrepreneur and the Wall Street titan meant that the assets being divided were no longer just houses and pensions. They were options, intellectual property, and brand value. How did the divorce attorney adapt when their client's biggest asset was a company that didn't exist 5 years ago? How did the prenuptial agreement go from a rare tool for the ultra-wealthy to a standard requirement for the American middle class? And what happens when a divorce attorney becomes a celebrity in their own right, managing the public image of a breakup just as much as the legal filings? In the next part, we will enter the 1990s, the era of the megadivorce. We will look at how attorneys began to value fame and future potential as marital property, and how the rise of the internet began to provide a whole new way to spy on a spouse. We are moving from the battle for the kids to the battle for the empire. The stakes are about to reach the billions. The battle for the empire began in earnest as the calendar flipped to the 1990s, an era that redefined the U.S. divorce attorney from a courtroom litigator into a sophisticated corporate strategist. While the 1980s were about the psychological warfare of custody, the 1990s became the decade of the intangible asset. As the United States moved from a manufacturing-based economy to one driven by technology, media, and finance, the things people owned were no longer just houses, cars, and pensions. They were stock options, intellectual property, and brand equity. This presented a massive challenge for the legal profession. How do you divide the value of a company that has no profit, but is valued at $1 billion on the NASDAQ? Imagine if you are a character named Alex in 1997. Alex is a software engineer at a burgeoning startup in Silicon Valley. He married his spouse, Jordan, before the company took off. Now the company is going public, and Alex's stock options are worth a theoretical $30 million. However, those options haven't vested yet. They are a promise of future wealth. In the 1950s, a divorce attorney wouldn't have known what to do with this. But in the 1990s, the attorney had to become an expert in executive compensation. The historical trends of this period show a surge in the use of the Black-Scholes model within family law. Originally designed for the financial markets to price options, divorce attorneys began hiring specialized economists to apply this math to marital settlements. The attorney had to argue whether these options were a reward for past service, making them marital property, or an incentive for future work, making them separate property. This distinction alone could swing a settlement by millions of dollars. The attorney's office now looked more like a hedge fund research department, filled with vesting schedules and SEC filings. Step by step, the discovery process underwent a digital revolution. Before the mid-90s, discovery meant boxes of paper. By 1998, it meant digital forensics. This was the era of the first smoking gun emails. Imagine the high-stakes moment when an attorney in 1999 recovered a deleted file from a spouse's 500-megabyte hard drive that proved the existence of an offshore account or a secret secondary life. The U.S. divorce attorney had to learn the language of IT professionals, understanding how to subpoena internet service providers like AOL or CompuServe to track a spouse's digital footprint. Case studies from this era illustrate that the first thing a savvy 1990s attorney would do was advise their client to change their passwords, a piece of advice that remains foundational in 2026. This decade also saw the rise of the celebrity divorce attorney as a media powerhouse. Names like Laura Wasser and Raoul Felder became household names, not just because of their legal skill, but because they understood the public relations aspect of a high-profile split. They realized that in a world of 24-hour news cycles, a divorce wasn't just won in the courtroom. It was won in the court of public opinion. If an attorney could frame the narrative in the press, they could exert immense pressure on the opposing side to settle quietly and quickly. This led to the quiet filing strategy, where attorneys would file papers on a Friday afternoon before a holiday weekend to minimize media coverage, or conversely, leak strategic details to gossip columnists to gain leverage. Intellectual property became another massive battlefield. Consider the case study of a successful musician or author in the 1990s. Their attorney had to grapple with the concept of residuals and royalties. If a songwriter wrote a hit song during the marriage, that song is a marital asset. But how do you value the next 20 years of radio play and streaming rights? Attorneys began using discounted cash flow analysis to put a price tag on a creative spark. They would look at historical trends of similar artists to project future earnings, effectively putting a dollar value on a client's talent. This was the era where fame itself started to be treated as a divisible asset, leading to complex arguments about whether a spouse's support contributed to the other's celebrity status. The 1990s also solidified the legal standing of the prenuptial agreement. While they had existed for decades, the passage of the Uniform Premarital Agreement Act (UPAA) by many states provided a clear step-by-step framework for making these contracts enforceable. Attorneys began to market prenups, not as a sign of a failing relationship, but as a business plan for a marriage. They became a standard requirement for anyone with even a modest amount of premarital assets. The attorney's role shifted toward risk mitigation. They had to ensure that both parties had full and fair disclosure and independent legal counsel, or the entire agreement could be tossed out by a judge years later. As we look back from the year 2026, the 1990s represent the moment the divorce attorney became the gatekeeper of the new economy family. The sheer volume of wealth being generated in the tech boom meant that the stakes had never been higher. A single mistake in a qualified domestic relations order (QDRO) involving a tech giant stock plan could result in a malpractice suit that would dwarf the original legal fee. This pressure led to the ultra-specialization of the bar. You no longer just hired a divorce lawyer. You hired a high-net-worth matrimonial specialist who worked with a team of tax attorneys, forensic accountants, and private security. The cost of these services mirrored the rising stakes. By the end of the decade, it was not uncommon for a contested megadivorce to see legal fees in the 6- or 7-figure range. The billable hour was no longer just about writing motions. It was about managing a multidisciplinary team of experts. Attorneys were now billing for strategic consulting, media liaison services, and asset tracing. However, as the 1990s drew to a close and the dot-com bubble burst, the landscape was about to shift once again. The empire that attorneys had spent a decade valuing suddenly began to shrink. The next challenge for the legal profession wasn't how to divide $1 billion, but how to handle the fallout of a national economic collapse. The 2000s would bring the rise of social media, the ubiquitous nature of the smartphone, and a level of surveillance that the private eyes of the 1950s could only dream of. What happens when your spouse's secret life is broadcast in real time on a digital wall for the whole world to see? How did the divorce attorney adapt when the evidence wasn't a grainy photo, but a GPS-tagged social media post? We are entering the era of the digital weaponization of the law. In the next part, we will explore the 2000s, the age of the digital smoking gun. You will see how the invention of Facebook and the iPhone provided attorneys with an endless stream of free evidence, and how the privacy of the home was forever destroyed by the very devices we carry in our pockets. We will look at how attorneys began to use metadata to win cases and why your deleted history isn't as dead as you think. The year is 2004, and the landscape of human connection is about to be terraformed by a college student in a Harvard dorm room. While the world saw the birth of social media as a way to poke friends and share digital photo albums, the U.S. divorce attorney saw it as something entirely different: a perpetual self-incriminating evidence machine. We are now entering the era of the digital smoking gun. Before this period, if an attorney wanted to prove a spouse was living a lifestyle beyond their reported income, they had to hire a private investigator to sit in a sedan for 3 days, hoping for a single grainy photograph of a new car or a luxury shopping bag. By 2006, that same spouse was voluntarily uploading high-resolution galleries of their trip to Cabo San Lucas to a public MySpace or Facebook profile. Imagine if you are a character named Chris in the year 2007. Chris is going through a contentious divorce and tells his attorney that he has no liquid assets and can barely afford his monthly child support payments. However, Chris's spouse has a savvy legal team that has just discovered Chris's public profile on a nascent social media platform. On this profile, Chris has posted a series of photos from a high-stakes poker tournament in Las Vegas, including a caption boasting about a $20,000 win. In the 1980s, this information would have been buried in a private conversation. In the 2000s, it became a matter of public record that could be used to impeach Chris's credibility in open court. The divorce attorney's role shifted from finding the truth to simply capturing the truth that the opposing party was foolish enough to broadcast. Historical trends indicate that by 2010, over 80% of matrimonial attorneys reported a massive spike in the use of social media evidence. This forced a fundamental change in how legal advice was delivered. For the first time, the very first instruction a divorce attorney would give a client during an initial consultation was not about the law or the children. It was about the internet. Step by step, attorneys began implementing a digital lockdown protocol. They would instruct clients to deactivate accounts, set profiles to the highest privacy levels, and most importantly, stop posting entirely. But this created a new legal conflict: spoliation of evidence. If an attorney told a client to delete a post that contained evidence of hidden assets or bad parenting, that attorney could be sanctioned, and the client could face a negative inference from the judge. The attorney had to become a digital archivist, ensuring that every piece of electronic data was preserved even as they tried to mitigate its impact. Then came the year 2007, the year the iPhone was released. This was the moment the U.S. divorce attorney gained a silent witness in every bedroom and every car in America. The smartphone was not just a phone. It was a GPS tracker, a high-definition camera, and a repository of every whispered thought sent via text message. Attorneys began to specialize in the extraction of metadata. Metadata is the data about the data. Imagine a scenario where a spouse submits a photo of themselves at home with the children as proof of their involvement. A sophisticated divorce attorney in 2026 would look back at the 2000s as the time when they learned to look at the EXIF data of that photo. That metadata could reveal the exact GPS coordinates and the precise timestamp of when the photo was taken, potentially proving that the photo was actually taken 3 years prior, or at a completely different location. The phone became the ultimate truth teller, and the attorney became the one who knew how to make it speak. But while the digital world was heating up, the physical world was collapsing. The 2008 financial crisis was a watershed moment for the U.S. divorce attorney. For decades, the primary asset in an American divorce was the family home. It was the source of equity that funded settlements and paid legal fees. Suddenly, in 2008 and 2009, millions of American homes were underwater, meaning the mortgage was higher than the home's market value. The divorce attorney had to pivot from being an asset divider to a debt negotiator. Consider a case study from 2009 in a state like Florida or Arizona. A couple wants to divorce, but their house is worth $300,000 less than what they owe the bank. In the 1990s, the attorney would have fought over who gets the house. In 2009, the attorney was fighting over who was stuck with the debt. This led to the rise of the short sale divorce. Attorneys had to learn the intricacies of mortgage law, foreclosure defense, and credit scoring. They had to coordinate with banks to allow for a sale that would leave both parties with a clean slate, even if it meant they both walked away with nothing. The potential outcomes of a divorce in this era were no longer about who got the bigger piece of the pie. They were about who could survive the economic fallout with their credit score intact. This financial desperation also led to a spike in white-collar discovery. As businesses failed, spouses began to suspect that the other was using the economic chaos to hide money. The divorce attorney had to dig deeper into corporate tax returns and bankruptcy filings. They began to see the emergence of the virtual asset, though in 2008, this mostly meant things like World of Warcraft accounts or early digital currencies. The concept of an asset was becoming increasingly abstract, and the attorney had to be the one to ground it in legal reality. By the end of the 2000s, the U.S. divorce attorney had also mastered the art of the text message thread. Before the smartphone, a heated argument between spouses was a matter of he said, she said. By 2010, it was a searchable, time-stamped, and permanent record. Attorneys began to use these threads to establish patterns of emotional abuse, or to prove that a parent was consistently late for pickups. The sheer volume of data was overwhelming. Law firms began to adopt e-discovery software, originally designed for massive corporate litigation, just to manage the tens of thousands of text messages and emails in a single domestic case. Step by step, the industry was moving toward a level of surveillance that would have been unimaginable to the practitioners of the 1950s. The divorce attorney was now a technician of the digital age, a navigator of economic ruin, and a manager of a client's online reputation. We see in the historical trends of this era that the cost of divorce continued to climb, not just because of the conflict, but because of the sheer amount of information that had to be processed. The billable hour was now dedicated to scrolling through 5 years of Facebook history and analyzing 2,000 pages of credit card statements. As we look at the year 2026, we realize that the 2000s set the stage for the hyper-connected, hyper-monitored world we live in today. But even as the technology evolved, the core of the conflict remained the same: property and children. However, a new player was about to enter the scene, one that would make the iPhone look like a toy. We are talking about the rise of the algorithm, the tracking of the digital wallet, and the era where your own car might testify against you in a custody hearing. What happens when your smart home records a private argument that changes the course of your life? How did the divorce attorney adapt when the biggest asset in the marriage was a digital coin that didn't exist in a physical bank? We are moving into the 2010s and beyond, the era of big data and the silicon divorce. In the next part, we will explore the rise of cryptocurrency in divorce, and how attorneys had to learn to track assets across the blockchain. You will see how the Internet of Things turned common household appliances into potential witnesses, and how the concept of privacy in the American home finally and completely vanished. We are entering the final, most complex phase of our history. As the calendar turned toward the mid-2010s, the U.S. divorce attorney entered a realm that felt more like a cyberpunk thriller than a traditional legal practice. The concept of the home as a sanctuary of privacy, a historical trend that had stood since the founding of the Republic, was finally and completely dismantled by the very technology designed to make life convenient. By 2015, the average American household was filled with silent digital witnesses. This era marked the rise of the Internet of Things (IoT) in matrimonial litigation, and it forced attorneys to become experts in the architecture of the smart home. Imagine if you are a character named David in the year 2017. David is involved in a high-stakes custody and asset battle. He claims to his attorney that he spends every evening at home, dedicated to his children. However, his spouse's attorney has subpoenaed the records from the family's smart thermostat and smart refrigerator. Step by step, the legal team reconstructs David's actual movements. The thermostat data shows that the heat was lowered to an away setting every evening at 8 p.m., and the smart refrigerator's logs show no activity until 2 a.m. This digital footprint effectively impeaches David's testimony. The divorce attorney's role in this era shifted from analyzing what people said to analyzing what their appliances reported. Case studies from this period show that even a smart doorbell-like Ring became a primary source of evidence, providing time-stamped video of every entrance and exit that could prove or disprove a spouse's claims of sobriety, fidelity, or parental presence. But as the physical world became more transparent, the world of wealth became increasingly opaque with the explosion of cryptocurrency. By 2014, Bitcoin had moved from a niche interest to a legitimate vehicle for wealth, and by the 2020s, the divorce attorney was facing the greatest challenge to asset discovery in history. In a traditional divorce, the attorney would follow a paper trail of bank statements and wire transfers. With cryptocurrency, the wealth could be stored on a device no larger than a thumb drive, or even a seed phrase of 12 words memorized or written on a scrap of paper. Consider a case study from the late 2010s involving a tech-savvy spouse who invested early in Ethereum. To hide these assets, they transferred the funds to a cold wallet, a hardware device not connected to the internet. The U.S. divorce attorney had to develop a new investigative protocol. Step 1. Review all bank and credit card statements for on-ramps, transfers to exchanges like Coinbase or Binance. Step 2. Subpoena those exchanges for account history. Step 3. Hire a blockchain forensic consultant. These experts use sophisticated software to map the movement of coins across the public ledger. Even if a spouse used a mixer or a privacy coin to hide their tracks, Historical trends in forensic accounting show that a persistent attorney could often find the point where that digital wealth touched the traditional banking system. The potential outcomes of a case could hinge entirely on the attorney's ability to explain the difference between a hot wallet and a cold wallet to a judge who might still be using a flip phone. The volatility of these digital assets created a new legal nightmare: the valuation date dilemma. Imagine a scenario in 2021 where a husband has 10 Bitcoin. At the start of the divorce, those coins are worth $600,000. By the time the parties reach the mediation table 6 months later, the value has plummeted to $300,000. The attorney must argue whether the asset should be valued at the date of filing, the date of trial, or the date of distribution. This led to the drafting of complex fluctuation clauses in settlement agreements, where the parties agreed to divide the number of coins rather than their dollar value, effectively sharing the risk of a market crash. The divorce attorney was no longer just a lawyer. They were a risk manager for a digital portfolio. Then came the year 2020, and the global pandemic accelerated the evolution of the divorce attorney by a decade in a matter of months. The traditional courtroom, with its wood-paneled walls and physical presence, vanished. In its place came the Zoom divorce. This was not just a change in venue, it was a change in the very psychology of litigation. Attorneys had to become tech support specialists, ensuring their clients had stable internet and a professional background. But the remote revolution also provided a new, unintended form of discovery. During a remote deposition, an attorney could literally see into the opponent's home. They could see the luxury items in the background, the presence of an undisclosed partner, or the state of the living environment. This era saw a fast-paced adoption of electronic signatures and digital filing systems, making the process faster but also more relentless. The boundary between the attorney's office and the client's home disappeared, with text messages and video calls happening at all hours of the night. In this high-pressure environment, the U.S. divorce attorney began to leverage predictive analytics. By 2022, elite firms started using software that analyzed thousands of past rulings from specific judges to predict the most likely potential outcomes for a given set of facts. If David's attorney knew that Judge Smith had a historical trend of favoring the primary breadwinner in alimony disputes 70% of the time, the attorney could adjust their settlement strategy accordingly. This was the beginning of the algorithm-driven divorce, where data was used to remove the emotional guesswork from the legal process. As we look at the current landscape of 2026, the attorney's office has become a fortress of cybersecurity. With the rise of state-sponsored hacking and high-value digital theft, a divorce firm's data is a prime target. A single breach could reveal the most intimate secrets and financial vulnerabilities of a city's elite. Attorneys now employ end-to-end encryption for all client communications and use AI-driven tools to scan for deepfake evidence. This leads to one of the most terrifying developments in recent history: the AI-generated spouse. Imagine a scenario in 2026 where an attorney is presented with a video of their client engaging in abusive behavior. The video looks perfect, the voice is identical, and the metadata seems legitimate. However, it is a sophisticated deepfake created by an angry spouse using a consumer-grade AI tool. The divorce attorney now has to hire digital authenticity experts to prove the video is a forgery. The battle is no longer just about the truth. It is about the very definition of reality in a digital courtroom. The complexity of the 2020s has also seen the rise of collaborative divorce as a mainstream alternative to the courtroom battlefield. Attorneys are increasingly acting as facilitators, working with neutral financial professionals and mental health coaches to settle cases without ever filing a motion. This shift reflects a growing realization that the legal system's traditional adversarial nature is often too slow and too expensive for the digital age. But even in a collaborative setting, the attorney remains the guardian of the client's future, ensuring that every digital coin and every smart home log is accounted for. The U.S. divorce attorney has traveled from the staged hotel raids of the 1950s to the blockchain tracking, AI detecting strategist of 2026. They have adapted to every social upheaval and every technological revolution. But as we move into the final chapters of this history, we have to ask, what happens when the AI doesn't just help the lawyer, but starts to replace them? What is the future of a profession built on human conflict when the conflict itself is managed by a machine? In the next part, we will explore the rise of robot lawyers and automated alimony. You will see how the first AI-driven divorce platforms are promising to settle cases in minutes instead of years, and the massive ethical backlash from the legal establishment. We will look at the fight for the soul of the profession as the human attorney battles to prove they are still necessary in a world of perfect algorithms. The final war for the future of the American family has begun. The final war for the future of the American family has begun, and the front lines aren't just in wood-paneled courtrooms anymore. They are in the clean white data centers of Silicon Valley. As we navigate the landscape of 2026, the U.S. divorce attorney is facing a crisis of identity. For over a century, the profession was built on the scarcity of information and the complexity of the law. A lawyer was the gatekeeper because only they knew where the precedents were hidden and how the judge usually ruled on a Tuesday morning. But today, the gate is being kicked down by large language models and specialized legal algorithms that can process 30 years of family court data in the time it takes an attorney to pour a cup of coffee. This is the era of the automated divorce, and it is fundamentally restructuring how the American public interacts with the concept of ending a marriage. To understand the gravity of this shift, we must look at the rise of the AI mediator. Imagine if you are a character named Sarah in the year 2026. Sarah and her spouse have decided to split. In 2010, Sarah would have spent $5,000 just to put a human attorney on retainer to start the paperwork. In 2026, Sarah logs into a decentralized legal platform. Step by step, an AI avatar, trained on the specific statutes of her state and the historical trends of her local county, conducts an intake interview. It doesn't just ask for names and dates. It uses sentiment analysis to gauge her emotional state and identifies potential areas of conflict before they even surface. It cross-references her financial disclosures with real-time API feeds from her bank accounts, investment portfolios, and even her digital wallets. Within 2 hours, the AI generates a 60-page settlement proposal that is mathematically optimized for what it calls equitable fairness. This equitable fairness is based on millions of data points from similar cases. Historical trends show that human judges are subject to decision fatigue and personal biases. An AI, however, doesn't care if it's 4:30 p.m. on a Friday. It applies the law with a cold, terrifying consistency. This has led to the rise of predictive alimony. In 2026, the era of the wildcard alimony award is effectively over. Attorneys now use tools that provide a confidence interval for any given outcome. If the algorithm predicts a 92% chance that a judge will award 3 years of rehabilitative alimony at $2,400 a month, the incentive to litigate vanishes. The U.S. divorce attorney has had to pivot from being an advocate to being an algorithmic auditor. Their job is no longer to argue for more money, but to argue that the data the AI used was flawed, or that the specific case study of their client contains a human variable the machine cannot quantify. But the legal establishment is not going down without a fight. We are currently witnessing a massive wave of unauthorized practice of law, or UPL lawsuits. State bar associations are filing injunctions against these AI platforms, arguing that a machine cannot exercise legal judgment. Case studies from late 2025 show a dramatic clash in Florida, where a major tech firm attempted to launch a flat-fee robot lawyer for uncontested divorces. The local bar argued that divorce is a holistic human event that requires empathy and ethical oversight, things a server rack cannot provide. This has created a bifurcated market in 2026. On one hand, you have the commoditized track, where middle-class families use AI to settle their affairs for a few $100s. On the other, you have the bespoke human track, where the wealthy still pay $500 an hour for the human touch. Let's dive into an imagine-if scenario regarding child custody in this automated age. Imagine a father named Marcus. He is using an AI-driven parenting app that is court-ordered. This app doesn't just track his schedule. It monitors his communication with his ex-spouse. Using natural language processing, the app flags aggressive or passive-aggressive tones in real time. If Marcus sends a series of angry texts at 2 a.m., the AI automatically logs this as a parenting deficit and adjusts its recommendation for his weekend visitation. The U.S. divorce attorney in this scenario is no longer a detective. They are a data interpreter. They have to stand before a judge and explain that the AI's toxicity score was a false positive caused by a misunderstanding of sarcasm or local slang. We are litigating the soul of the machine. This leads us to the black box problem. When an algorithm decides the trajectory of a child's life or the distribution of a family's lifetime savings, who is responsible for the why? In 2026, we are seeing the emergence of a new legal specialty, the AI forensics attorney. These lawyers don't study the law as much as they study the training data. They look for historical bias. For example, if an alimony algorithm was trained on decades of data from an era where women were paid less, the AI might inadvertently bake that historical trend into its modern recommendations. The attorney's role is to debias the outcome. They are the human firewall between the client and a potentially prejudiced machine. Furthermore, the fast-paced nature of the 2026 legal market has given rise to microlitigation. Instead of a 3-day trial, attorneys are engaging in digital arbitration sessions that last 15 minutes. Evidence is uploaded to a secure cloud, an AI summarizes the key points of conflict, and a human judge or a senior attorney acts as a validation point, clicking accept or reject on the AI's proposed ruling. This has increased the efficiency of the family court system by 400%. But at what cost? Critics argue that we are losing the dignity of the process. The U.S. divorce attorney of the past was a witness to a family's transformation. The attorney of 2026 is often a manager of a digital assembly line. Consider the complexity of virtual assets in 2026. We aren't just talking about Bitcoin anymore. We are talking about digital real estate, in the metaverse, and non-fungible IP, in the creator economy. Imagine a couple that owns a virtual storefront that generates $10,000 a month in passive income through digital clothing sales. How do you value the goodwill of a virtual brand? A U.S. divorce attorney now has to hire virtual appraisers and avatar psychologists to determine how a split will affect the brand's value. The step-by-step process of discovery now involves blockchain crawlers that trace every transaction back to its origin. The potential outcomes are no longer just about who gets the house in the suburbs, but who gets the coordinates in a digital world. As we move toward the final chapter of this deep dive, the question isn't whether the U.S. divorce attorney will survive, but what they will become. We have seen them evolve from the moral detective of the 1950s to the financial architect of the 1990s, and now to the data strategist of the 2020s. The industry has proven to be incredibly resilient, always finding new ways to monetize conflict, even as the nature of that conflict becomes more digital and less human. The billable hour is being replaced by subscription-based legal protection and success fees based on algorithmic performance. But there is one thing the machine still cannot do. It cannot sit in a room with a grieving parent and say, "I understand." It cannot navigate the irrational, beautiful, and messy territory of human forgiveness or the nuanced best interests of a child that doesn't fit into a data set. The final evolution of the U.S. divorce attorney is perhaps a return to their most ancient roots, the counselor. As the law becomes automated, the counsel becomes the only thing worth paying for. What is the ultimate endgame for the American family court? Is there a world where divorce is so automated and so efficient that the adversarial system itself collapses? And what does the perfect divorce look like in a society where every move is tracked and every outcome is predicted? We are about to conclude this masterclass with the most provocative vision of the future yet. In the 10th and final part, we will look at the post-lawyer era. We will examine the secret pre-birth contracts being drafted in 2026 and the rise of smart marriages that automatically dissolve based on preset triggers. You will see the final synthesis of 300 years of legal history as we ask, is the U.S. divorce attorney the architect of the modern family, or its final most expensive casualty? The conclusion is not what you expect. We are now witnessing the arrival of the smart marriage, a concept that would have been viewed as science fiction by the practitioners of the fault-based 1950s or even the high-flying 1990s. In the year 2026, the U.S. divorce attorney has moved from being a reactive litigator to a proactive engineer of digital social contracts. A smart marriage is essentially a legal document built on a blockchain, a self-executing agreement that monitors the health of the partnership through predefined data triggers. Imagine if you are a character named Marcus in 2026. When Marcus married his spouse, they didn't just exchange vows. They signed a decentralized marital protocol. This protocol contains a series of if-then statements. If the couple's shared bank account detects an expenditure on a high-risk asset without dual authorization, a mediation alert is triggered. If the couple's shared physical location data shows they haven't spent more than 4 nights a week in the same residence for 3 consecutive months, the contract automatically moves into a pre-separation phase. The role of the attorney in this scenario is to write the social code. We are seeing a historical trend where the most elite matrimonial firms are hiring software developers to work alongside their senior partners. They are drafting, self-executing prenuptial agreements. In the event of a breach of a specific clause, perhaps a clause regarding financial transparency or fidelity, verified by digital forensics, the contract can automatically redistribute a portion of a cryptocurrency wallet or change the access permissions to a shared digital asset. The potential outcomes of these smart marriages are a radical reduction in the duration of the legal process. What used to take 18 months in a crowded family court can now be settled in 18 milliseconds by an algorithm. However, this leads us to the most complex legal frontier yet, the pre-birth parentage contract. In the 1980s, we saw the battle for the kids become a psychological war. In 2026, we are moving that war to the preconception stage. Attorneys are now drafting agreements that dictate every aspect of a future child's life before they are even born. These contracts cover everything from the genetic screening protocols to the educational path and the parenting style that will be enforced if the couple separates. Step by step, these agreements create a parenting utility that exists independently of the marriage. Case studies from early 2026 show that these contracts are increasingly being used to prevent the custody wars of the past. If the parents separate, the parenting utility script takes over, automatically assigning time and financial responsibility based on the data collected during the child's early years. The divorce attorney here is acting as a visionary architect, trying to predict and solve every possible human conflict through a binding digital script. But as we reach the pinnacle of this technological evolution, we are faced with a paradox. We have created a system of perfect efficiency, but we may have lost the human equity. Let's look at an imagine-if scenario involving a character named Elena in late 2026. Elena is using an automated alimony calculator that is so advanced it factors in the current inflation rate, her career trajectory, and even the local cost of living in the city she plans to move to. The system provides a number that is mathematically perfect. But Elena's attorney, a human specialist, notices something the machine missed: the subjective contribution. Elena spent 3 years caring for a sick relative of her spouse, a sacrifice that isn't captured in a bank statement or a GPS log. This is where the U.S. divorce attorney finds their final most essential role: the advocate for the intangible. The historical trends of the last 300 years show a clear progression. We began with the moral divorce of the 1700s, where the attorney was a guardian of religious and social norms. We moved to the economic divorce of the 1900s, where the attorney was a partitioner of property. We evolved into the psychological divorce of the late 20th century, where the attorney was a manager of trauma. And now, in 2026, we have reached the algorithmic divorce, where the attorney is a debugger of data. Through every phase, the attorney has acted as a mirror of American values. When we valued land, they fought over acres. When we valued the soul, they fought over sin. When we valued the mind, they fought over custody. And now that we value information, they are fighting over the data stream. This brings us to the ultimate question. Is the U.S. divorce attorney the architect of the modern family, or its final, most expensive casualty? The conclusion is that they are neither. They are the adaptive constant. The legal industry has proven that as long as two humans can form a bond, they can also find a reason to break it. And as long as that break involves assets, children, or identity, there will be a need for a professional to navigate the exit. The perfect divorce of the future might be one where you never see a courtroom, but you will still need an attorney to ensure the code is fair, the algorithm is unbiased, and the human story isn't lost in the digital noise. Consider the data on the post-lawyer movement. While AI platforms are handling 60% of uncontested filings in 2026, the demand for high-conflict human specialists has actually increased. This is because the more automated the system becomes, the higher the stakes for the cases that fall outside the norm. When the machine says no, you need a human to find the yes. The U.S. divorce attorney has successfully professionalized the most painful human experience, turning a social tragedy into a sophisticated, multi-billion-dollar technical service. They have survived the death of fault, the rise of no fault, the explosion of digital spying, and now the arrival of AI mediation. As we look toward the year 2030, the deep dive into this history reveals a startling potential outcome: the preventative divorce attorney. We are seeing firms offer marriage insurance policies, where an attorney is kept on a monthly retainer not to end the marriage, but to constantly update the marital smart contract as the couple's lives evolve. They are becoming the general counsel of the American household. This shift from crisis management to ongoing compliance is the final synthesis of 3 centuries of legal history. The divorce attorney is no longer waiting at the end of the road with a subpoena. They are riding in the passenger seat with a map and a laptop. The American family has been redesigned, deconstructed, and digitized, but its core remains a complex web of promises and expectations. The history of the U.S. divorce attorney is the history of how we, as a society, have tried to make those breakups fair, efficient, and just. From the staged raids of the 1950s to the blockchain settlements of 2026, the attorney has been the one to translate human pain into a legal decree. They have been the architects of our transitions, the managers of our secrets, and the auditors of our lives. But even as the robot lawyer takes over the paperwork, a new mystery is emerging. In a world where every marriage can be automatically dissolved by a digital trigger, what happens to the concept of commitment? If the exit is too easy, does the entrance lose its meaning? And as we look at the global stage, we see that the American model of the professionalized divorce is now being exported to every corner of the world. The story of the U.S. divorce attorney isn't over. It's just entering a new global dimension. We have mastered the domestic war, but the international data war is just beginning. What happens when a smart marriage involves 2 different countries, 3 different blockchains, and a child living in a virtual jurisdiction? In our next deep dive series, we will step outside the borders of the United States to look at the global divorce superhighways. We will explore the secret divorce havens of the 2030s and how international law is struggling to keep up with the digital nomad family. You will see how the U.S. divorce attorney is becoming a global jurisdictional navigator, and why the most important document you own might soon be your transnational marital protocol. The boundaries are disappearing, and the stakes are going global.